This video tutorial is for an answer to an unlawful detainer complaint. This is form UD-105. You'll start by typing your name, your street address, your city, state, and zip code. You can include also your telephone number and email address if you would like to. Moving down, you'll type in County of Siskiyou, unless you are filing this in a different county, and if that's the case, type in the county where you will be filing this. You will also need to find the address for the court in that county. However, if you are filing in Siskiyou County, the address is 3114 4th Street. The mailing address is 311 4th Street, room 206. And it's the family/civil branch. So plaintiff would be your landlord. Defendant is you. And case number should be listed on the complaint. So enter that number here. Okay, paragraph number 1 asks for the names of the defendant that this answer applies to. What this means is if you have a roommate or somebody else who was on the lease and that person is also being sued, you have to decide whether you're going to file one answer for both of you or if that person is going to file their own answer. Either way, you have to put somebody's name here, so let's just put you, or could be you and your roommate. Okay, now down to paragraph number 2. So if the complaint for eviction is not asking for any money and you deny everything in that complaint, you may check box A, which basically says that none of it is true and you disagree with being evicted. If, however, the complaint is seeking damages or past rent more than $1,000, then you will have to mark box B. So what that means is you have to decide what parts of the complaint are true and what parts of the complaint are not true. So starting with number 1 here, defendant claims the following statements of the complaint are false. So the complaint that you received from the landlord will be numbered. It'll have all the different paragraphs. You need to go through and you need to list each of the paragraph numbers that you think are lies, false, not true, or just not accurate. Okay, now number 2 here. If you don't know if something in the complaint is true or false, you can just generally deny it, which means that you'll preserve your right to make that argument when you go to court. What you need to do then is list all of the paragraph numbers that you just don't know if they are true or false. So I'm going to give you a little bit of a for example. I've switched and I put up the actual blank complaint just to use for demonstration. So if you'll notice that all of the paragraphs are numbered, and these are the numbers you will refer to when you're filling out your own answer as to whether you agree or disagree with it. So let's say that the complaint said that you moved in or had your agreement on January 1st, 2000, and you agreed to rent the property month to month for 1 penny per month. So if you were looking at your answer, so here defendant has no information, so denies each paragraph. So let's say that you did not believe that you rented the property for a penny per month, and this is paragraph 6 that says that you did. So you would go back to your answer and you would write in paragraph 6. And that way the judge knows that you are specifically taking issue with paragraph 6. And then you would do that all through the rest of the complaint, just noting each of the marked paragraphs. So it goes on the next slide, continue paragraph 6, 7. You just would keep going through all of them, marking down the ones that you disagree with. Okay, back to your answer. So we're now at number 3, where you list your affirmative defenses. So the first set of defenses are prepared standard form defenses that are the most common. You'll just need to check the box that that's what you are going to be alleging. So let's look at them one by one. So number A, letter A actually, says plaintiff has breached the warranty to provide habitable premises. What this means is if you have not paid rent because your apartment, house, trailer, whatever is completely gross and you could not live in it and it needed a lot of work and that's why you didn't pay rent, then you can mark this box. When you get to trial, you will need to have some evidence of why the property was not habitable, so just keep that in mind. But if that's what happened, mark that box. Okay. The next one, letter B, if you made repairs that were absolutely necessary and you took off the cost of those repairs and that's why you're being evicted, then mark this box. For example, if the hot water heater leaked and you needed to replace it and you replaced it and it cost $500, then you took that $500 off your bill or off your rent and now you're being evicted, so mark box B as your defense. Okay, now we're down to C. Again, this is only for an eviction based on failure to pay rent. So if you tried to pay the back rent that was due and the landlord did not accept it, write down the date you tried to pay and mark C. Okay, next one, D. Plaintiff, landlord, waived, changed, or canceled the notice to quit. So let's say that they gave you a notice to move and then later they gave you a letter saying that we're not going to enforce that notice to move. Then you would mark D. Now E, landlord served defendant with a notice to quit to retaliate against you. So if you think that's the case, mark E. You will need to explain what happened but go ahead and you can use that as a defense. F is if you believe that they are discriminating against you on the grounds of things like your race or your gender or your sexual preference, then you can put that box down. G, the landlord's demand violates local rent control. So in Siskiyou County, this is not going to apply. If you are being evicted in a bigger city, then this might be something for you to look into, whether there is any housing or local rent control in your area. That doesn't apply here in Siskiyou. Okay. H. So if the landlord gave you a notice to quit, and then after the time of that notice to quit expired, still accepted rent from you, then that's a defense to being evicted at this point. So if that happened, check H. And I is meant to protect victims of domestic violence, sexual assault, stalking, trafficking, or elder abuse. So if you are a victim of um, then you should not be being evicted, and you can check that box. However, you will notice that you will need to prove that you have at least a temporary restraining order, a full protective order, or a police report explaining what happened. J is the kind of catch-all, which is the chance for you to provide some other defense or reasoning as to why the landlord should not be able to ask the court to evict you. You will have to So you need to write in what your defense is, explain in detail and in your own words why you think you should not be evicted. If you run out of space, you can check the box there and attach additional paper, this form MC-025, which you can find online. Down to number 4 here. If you have left the premises, then mark that box and put on the date you moved out. That way the court will know that you've already left and that part of the issue is over. There are times when a landlord will claim a fair daily rental value of the property. If you believe that that amount that they are claiming is not correct or not fair, then just just explain why the property is worth less than what the landlord has put. Finally, you can write anything else that you want the court to know about your relationship with the landlord, about the condition of the house. You can make sure that you tell your story. This is a good opportunity to do that. Okay. So you're asking, it's just coded already there that plaintiff take nothing, which means that you get to stay there and you're not responsible for any costs or otherwise. You can ask for a return of your costs that you incurred, which means if you had to pay a filing fee, then you can ask for that back. If you end up having reasonable attorney fees, which means you have actually paid money to an attorney to help you with this, then you can ask for fees, but you cannot get attorney fees unless you have actually retained an attorney to help you. D, if the reason why you didn't pay rent is because the property was in a shambles or there was something else wrong with it, you can ask that the landlord be ordered to fix those problems so you can stay living there. Again, there's another opportunity for you to ask for something else. If anything else comes to mind and you want to just type in basically any other request from the landlord. Okay. If you end up attaching other pages, just count up those number of pages and put that number there. Okay, so if you are doing this on your own, even if you have a friend or family member helping you, then you did not have an unlawful detainer assistant. If you had an unlawful detainer assistant, you would know because you would be paying that person, and they would have to put in their information here. It is most common to mark the box did not. Then you will type your name or write it. Then you'll sign over here. If there are So if you were filing this with somebody else, so there are two of you, then the other person who would also be your co-defendant would end up putting their name down and signing it. And then finally, one more time on the bottom here, one of you needs to type or write your name and then sign it, and then uh, file it with the court and serve a copy on the landlord or the landlord's attorney. That information will be on the summons.